Renters in Oregon face unique challenges in ensuring they have a safe and clean water supply. In this episode of Oregon Water Matters, we will discuss questions like, what protections do I have as a renter to save water? What makes water safe to drink and use? How do I know if my water is safe? What rights do renters have if their water is unsafe or insufficient? Let's dive right in. As a renter, what protections are in place to ensure my water is safe? Oregon residential landlord and tenant law provides rules for landlords and renters. The law requires landlords to maintain habitable premises for tenants. To be habitable, the premises must include safe drinking water, hot and cold running water, functional plumbing fixtures, and a working sewage disposal system. What makes water safe? The Oregon Health Authority regulates water systems serving the public to ensure safe drinking water. To protect public health, the Oregon Health Authority adopts standards designating maximum contaminant levels and water testing requirements. Only public water systems are regulated under the drinking water rules. However, the drinking water quality standards provide a threshold for whether water from all sources is safe. Public water systems are required to report any failure to meet drinking water quality standards to all persons served by the water system. This includes renters, even if they are not named on the water bill. The public notice must acknowledge that drinking water quality standards have not been met, describe the health risks and who is most vulnerable, and explain the actions water users should take to protect themselves. While most renters rely on public water systems for water, some rely on domestic wells. Domestic wells are not regulated to ensure drinking water safety, but the Oregon Health Authority still recommends testing well water for contaminants. The Oregon Health Authority has some resources to support well testing, including information about how to test wells and review results. In some parts of the state, there is funding available to help with the cost of testing domestic wells. Some common contaminants in groundwater are bacteria, nitrates, and arsenic. In most cases, landlords are not required to test domestic wells to ensure they provide water that is safe to drink. Landlords are also not required to pay for testing, even if their renter requests a test. It is still recommended that renters test well water to ensure it is safe to use. If a renter finds a water quality issue, their landlord may have an obligation to correct the problem. In 2025, the Oregon legislature passed a law that requires landlords to test wells that supply drinking water in areas designated as groundwater quality management areas. These areas have levels of contaminants that significantly exceed safe drinking water standards. Starting in 2027, landlords with rental properties in groundwater quality management areas that rely on domestic wells will be required to collect and test well water and provide information to tenants about the safety of their water supply. Existing groundwater quality management areas include portions of the southern Willamette Valley, northern Malheur County, and northern Morrow and northwestern Umatilla counties. In all other areas of the state, renters will remain responsible for testing their domestic wells. Even though most landlords are not responsible for testing water, they still have a role to play in ensuring renters have access to safe water. Landlords must make necessary repairs to address insufficient or unsafe water supplies as long as the issues are within their control. For example, if renters do not have access to safe water because of faulty water fixtures, their landlord is responsible for fixing that issue. For renters served by a public water supplier, the unsafe condition may be related to the public water supply. For example, contaminated water. In these cases, the public water system should provide information and resources to address the conditions. But what happens if a landlord knows about a problem and doesn't fix it? The Residential Landlord and Tenant Act gives renters certain remedies if a landlord is not meeting obligations to provide a safe and sufficient water supply. First, the renter must inform the landlord of the issue and make a request for repair. If the landlord does not act after receiving the request for repair, the renter has a few options. For minor repairs that cost less than $300, renters can make an agreement with their landlord to pay for the cost of the repair up front. Then, the landlord would deduct the total amount from that month's rent. In some cases, renters may also be able to sue their landlord for damages. When the issue is severe enough that renters may face serious danger or health risks if they remain in their home, renters may have additional rights related to payment of rent or terminating their lease. Before pursuing any of these options, renters should consult with an attorney to better understand their rights. Remember, landlords can sue their tenants for violating rental agreements. Renters should keep careful records of habitability problems, their communications with landlords, including any request for repair, and all expenses related to the problem. With that, let's recap what we've discussed in this video. Oregon law requires landlords provide habitable premises, which includes a safe water supply. The Oregon Health Authority sets standards for drinking water quality. Public water systems must provide information about water safety to their water users. Most renters relying on domestic wells are responsible for testing their water to ensure it is safe. A new law will take effect in 2027 requiring landlords to test wells in areas of the state with known public health risks from groundwater contamination. Oregon's residential landlord and tenant law gives renters remedies when a landlord won't address a habitability concern. For more information, check out the rest of our series. And remember, Oregon water matters.